topic today really fits into a series that we've been discussing about empirical legal studies with a focus on how law and psychology in particular can contribute to that body of work. And today's topic in the next hour is going to focus on memory as evidence, particularly in cases of child sexual abuse. And I'm going to take a seat in a moment to work through all of the details, but I do want to just outline at the start that I need to acknowledge my co-authors who prepared this report for me at the request of our Royal Commission into Institutional Child Sexual Abuse. So that's Mark Nolan from ANU and Evian Grosvenor van Rijn, who's a postdoc and completed her studies at Cambridge University, focusing on grooming in the child sexual abuse arena. What I'm going to do is sort of walk you through the core content of our report, which is about 185 pages, so this is going to be a rapid kind of summary. I'll try to get what I have to say done in 40 minutes and leave 20 minutes for you to ask questions at the end. So please hold all of your questions for a little later. So without further ado then, I'm going to kick off by just giving you a bit of background on the context that really motivated our Royal Commission to focus on these questions. And the first critical thing is to realize that there is a very well documented high attrition rate of sexual abuse cases, or sexual assault cases, or rape cases as they're called in some jurisdictions, and that this is particularly high with respect to child sexual abuse all the way through the criminal justice system. So if we look just at convictions, the statistics I put up there are from my state of New South Wales, which is the biggest state in Australia. And it shows that, you know, over the period 2012 to 2016, the overall conviction rate, taking into account also guilty pleas in all matters, was about 89%. But if you look at child sexual assault offenses, it's considerably lower and statistically significantly lower. You know, it's only 60%. And if you then tease apart the matters, you know, separate out those that had guilty pleas and just look at cases that went to a contested trial or hearing, you see the prominence of acquittal. Because in fact, you know, there are 52% total acquittals, and most of these cases have multiple charges or counts. And for those where some of the counts were convictions and some were acquittals, it was about 16%. So that really tells you that the number of convictions in cases that go to trial is really just around, you know, 30 to 32% at most. So that's quite alarming for our prosecutors and quite alarming for the victims as well. And so part of what has motivated the Royal Commission's work is to try to address what appears to be, in this particular arena of law, not miscarriages of justice in the form of wrongful convictions, which has been such a focus in so many law schools with wrongful conviction clinics and so forth, you know, looking at problems with eyewitness memory, faultily leading to convictions, or even with DNA evidence that is erroneous. What seems to be the problem here, where the balance of justice is distorted, is that there are in fact wrongful acquittals rather than wrongful convictions. And all of these other data that I have up there just kind of underpin this point by comparing it with other types of crimes. You know, the only category where the conviction rate generally was lower at all was with adult sexual assault or rape, and what has been noted there by the legal community is that, like child sexual abuse cases, there are also word against word cases where there's no other independent corroborating evidence generally, but then in the adult cases, most typically consent is the defense, whereas in the child sexual assault cases by statute, no, consent is not the issue. And so that might be one of the reasons for that statistic. So When we look at memory research and how that bears on these cases, we see that by and large in the law psychology movement, most of the memory research has been focused on issues that really play into the defendant's case. And they focus on errors in memory that then experts who are retained by defense counsel bring into court in order to show that an identification is faulty or shaky or doesn't meet the burden of proof. And so there is a vast repository of research, from at least very intensively since the 1970s and carrying on to the present, focusing on what we call event memory for bystander eyewitnesses that really seems to have very little to do with victim memory for a personally intrusive event where you're not a bystander but you are the victim, and particularly when that is about a memory of a childhood event. So relatively little is known by comparison, even though studies have been done of children's development in memory, but little is known or is accessible, particularly to the legal profession, on how children remember, what they remember well, what they don't remember well. And so part of the focus of our study for the Commission was to try to address that gap in the scientific literature. There's quite a paradox of proof that the legal profession have observed, and our Royal Commission ran many hearings and took testimony and evidence from over 5,000 adult victims with historical claims, so they were victims as children, but they're adults now, or of children reporting childhood sexual abuse, in which, after hearing these repeated narratives over and over again, they gathered a very strong sense of what was common in the narratives and how that might have a bearing on the legal requisites of proof in a trial. And they found that there was a great paradox in that people who had been abused on a one-off occasion or a single event tended to have a better capacity to narrate and report that event than people who had been victims of multiple repeated incidents of sexual abuse that many times went on for years, entailing thousands upon thousands of separate events of assault. And those individuals, they then said, tended to be the least capable of providing the specifics or the particularization that is required legally, so that the accused is well equipped to defend himself or herself against the specifics of the allegations, because their memories are deficient in producing those specifics. And so that has prompted different legal communities over many decades to do different things. When I dug into the legal research on this, I found that in California this issue was first identified around the turn of the century, 1900, but it took about another 90 years before actually any legislation addressing what are called persistent offenses against children was actually developed. And we see that only in about 1989 in Australia was legislation enacted to try to address this problem by creating an entirely separate offence of persistent child sexual abuse. And I've highlighted there one of the examples of this from Queensland, where it says that you have the offence of maintaining a sexual relationship with a young person, and then you have to enumerate at least 3 events in a specified period of time that are discrete events of abuse in order to satisfy the requisite proof for that offence. And the problem is, it's much harder then, even for a complainant to meet that standard than to meet the standard for just remembering one single event. So this tended to backfire, and then particularly when the High Court looked at the case of KBT versus the Queen, they made it even more difficult by insisting that jurors who typically hear these cases in the Australian trials must agree on the 3 events that are specified beyond reasonable doubt in order for the prosecution to secure a conviction. And so that itself meant that this entire provision intended to address the memory problem has failed and remained underused because it's just so difficult to deal with. And so more recently, Queensland has tried to amend that process, by saying jurors don't have to agree, and they've sort of changed it, and you only have to have 1 event within a specified time period, and we're not really sure how this is working out just yet. But the major concern that social scientists would have is that none of these reforms have been empirically based. The reforms have been made, based on sort of tinkering around with pieces of the law that worked or didn't work to try to work better. And what really is the capacity to remember. So our report was to address a number of aims. And we wanted to provide some general information about, fundamental human memory processes. We weren't looking at specific cases or specific individuals, so we're looking at normative behavior, aggregated studies of how most normal people behave, rather than particular individuals. And we wanted to produce a summary that was accessible to members of the legal profession, particularly, to assist police who are doing investigative interviews, judges and lawyers who have to deal with these cases before and during trial, and also the juries who have to hear them because they need to be given directions about memory processes by the judges, and if the judges aren't informed, they're not going to have the wherewithal to inform the juries, and so the problem becomes compounded, particularly if people harbor misconceptions about memory. So part of what we focused on was the misconceptions, and I'll leap into that next. In order to accomplish our task, we conducted a large-scale literature search with the assistance of various research assistants in law and psychology. We focused on meta-analyses where they existed, where they didn't exist. We focused on literature that had been published really in the last decade. And that's because in around 2007, the British Psychological Society published an interesting document that is a guide intended for the legal profession on general memory operations. And so we took that into account, and we didn't want to repeat what the British Psychological Society with a national and international group of consultants had accomplished. Although they were not focusing at all on children, they were focusing on any witnesses or victims in any kinds of cases, but they still had to describe basic memory processes. So you can track that down and have a look at what the British Psychological Society has published on this topic, and compare it with our report and our summary, which focuses on children. We also, after we drafted our report, and we summarized about 750 different primary research reports to aggregate these sort of black letter principles of memory for you, we consulted with some of the leading memory researchers and practitioners from the clinical and forensic arena who work on child sexual abuse cases to try to ensure that we hadn't missed areas or topics that police and courts needed to know about in this arena, and we held a public round table with them. The transcript of that round table discussion conducted by the Royal Commission is available on its website if you're interested in reading all of that. And then ultimately our report went through a peer review process. So we had to classify the types of memory research that exist. And as I've indicated, a lot of the lab studies really are not apt for this kind of problem because they focus on eyewitness memory of a bystander who watches a criminal event and is not a participant, or not a child. And although those studies are very, very important because they are experimentally controlled and you can tell what the causation and outcomes are, they had some limitations in terms of what we could generalize to this literature. So we had to look further afield. So we looked next at what are called some of the false memory studies, because that's been very, very prominent since about 1990 in the area of law and psychology. And, and probably if I said to you, have you heard of false memory, research on false memory, you would all nod your heads affirmatively, because it's been very well publicized. And we wanted to sort of set that research in perspective in this context. And what happens in those studies, which are laboratory controlled experiments, is that people are usually exposed to different kinds of misinformation. Sometimes it's a word list, and then they have to indicate when they're given a recall test whether the same word has been presented to them before or not. So it's very far afield from the kinds of things that we're interested in about child sex abuse, because word list memory and semantic memory is very different than a physiological experience. The other kinds of research that is done sometimes is to try to implant a false memory in someone by using family photographs and doctoring them, making a sort of a fake picture that has all of the family members but a false event, and then seeing whether you can apply social pressure to somebody to get them to endorse that, yes, they do remember this event that never in fact occurred. And the third kind of study is really just manipulating the kind of questions that are asked by suggesting information that is untrue in the question in an implied way, and seeing whether somebody answering the questions then picks up that false information and incorporates it into their memory in a subsequent test. So most of those focus on suggestibility, which is clearly an issue with children, and so we wanted to look at children's suggestibility, but we had some reservations about the extent to which the false memory paradigm might generalize, and we were particularly assisted because in the last few months there have been a number of meta-analyses of those effects, and they tend to show that actually far fewer people than all of us think are really susceptible, even under those idealized lab conditions. So what we ended up thinking was that if people are not that susceptible to this influence under an idealized condition, it's probably true that in the real world that people are even less susceptible, because there aren't those same pressures imposed upon them in the real world. The numbers of susceptibility are actually astonishingly low. In those lab studies, only about 15 to 29 or 30% of all people are actually susceptible to the suggestion. So the main message from the false memory research is that people are very good at resisting suggestion. And that's not a take-home message that you often hear. So, I think one of the most important things that I can bring to you is to put that in perspective, notwithstanding anything to do with child sexual abuse or any other topic, that in fact we're quite resistant and have more robust memory processes than has generally been indicated, particularly to lawyers. The next kind of studies that are quite useful are called analog studies by us, because what the researchers do is they try to generate a controlled experiment where, for ethical reasons, they can't abuse people, so they look for an event that is somewhat similar, that has some sort of features. So they might ask people about genital touching in a medical examination or with dolls, they might ask them about their memories of intrusive medical procedures if they've had injections or something like that, where their bodies have in fact been touched. What is very different about those kinds of studies is that usually if you're going to a medical provider and you undergo, these procedures, whether it includes genital touching or not, the purpose of the consultation is usually for the welfare of the child, whereas that's not the case in a situation of child sexual abuse. So there's a very different context surrounding them that might be one limiting factor in terms of generalizability to child sexual abuse studies. But we summarized all of those And then we also looked at field studies for actual real-life traumatic events. And so those were of different sorts, and in some cases they were natural disasters, and children were interviewed after natural disasters about their memories, or sometimes they were, again, hospital visits. There are quite a lot of hospital visit studies, some of which have really thorough procedures. And we found those quite a useful database source to give us a better idea of what people remember about real-world events and real-world experiences. The limitation of those studies is a methodological one, because it's very difficult to know exactly what the ground truth was at the time of the event from the perspective of whoever the victim was. You don't necessarily have any information of that sort. And a second major threat is scientifically that there are often selection biases in who participates in this kind of study. So you might be losing a lot of people who have valuable but somewhat different experiences to narrate, because you can only get who you can get after the fact. Okay, so that's our core database. So before going further into some of the information that really explores in more detail some of the common misconceptions about memory, I thought I would give you a list of just statements about memory, and if you can just jot down for yourself, which number you think is the incorrect statement. Okay, so I hope you've had a chance to read through those and make your notes. Well, I shouldn't have asked you that question, because in fact they're all incorrect with the exception of one. So there's only one correct statement there, and it is the one that memory is like an improvisation that changes with each performance. All of the rest there are wrong. So if you thought anything differently, then you hopefully will not have that view at the end of this lecture. So let's have a look now at what we call some of the differences between common sense about memory and what the scientific body of research does show about human memory performance. So most of this research has been done by contemporary memory researchers who field surveys where they produce items such as that list of statements I just gave you, and then people have to rate the extent to which they're accurate or inaccurate, and then the results are compared by professional groups. So you might compare lay jurors with judges or with police officers, with memory experts or memory researchers, and see how many are correct in each of those different groups. And what this body of research has shown, and it's done throughout the world, is that there's quite an extensive gap between what memory researchers know and what members of the lay public or those other professions know. And that in fact sometimes police officers, for example, endorse entirely contradictory beliefs about memory. So there are inconsistencies even in their constellations of the belief system that they have generated about human memory. And I've listed there the extent to which there's agreement or disagreement, and you can see it varies by different groups. But the main topics of difference that came out of this research had to do with the extent to which children could be accurate, the extent to which memories can be repressed for a long time and then either spontaneously recalled or recalled under therapy by a psychotherapist, so someone who doesn't recall being abused as a child then produces a narrative of recall, which has received enormous publicity in the legal community. In reality, it's a very small percentage, and in reality, you know, it's so small that it wasn't a focus of what we wanted to do, because we really wanted to focus on more normative kinds of situations. So a lot of that work is all on suggestibility. Suggestibility, I've already addressed, but in this case, it's suggestibility mostly by the therapy provider who's just not attentive to the influence of the types of questions on particularly, you know, vulnerable, upset people going to therapy. And so that has led to a lot of misconceptions. People don't know about rates of forgetting, and they also think that we're much more vulnerable to post-event suggestions from others and there are differences in the extent to which people understand the impact of wording of questions on memory, and beliefs about hypnotic suggestibility. So those are key areas to focus on, and I am going to move into a slightly more refined way to talk about those differences, which comes from some work done at the City University of London by Martin Conway and colleagues, which has included sort of factor analyzing all of those survey kinds of results, which produced 8 categories of factors where these common sense beliefs and scientific beliefs diverge. So this is a summary of those. And the first one is that the experts are much more likely to endorse the view that memory is full of, the ordinary human memory has a lot of inaccuracies in it, or we expect it to have inaccuracies in it. Notions that the more detail you can remember, especially fine-grained details, the more accurate your memory is for core central events, is a proposition very well endorsed by the law. You'll probably find it in the jurisprudence of many, many jurisdictions. And that's not accurate under the findings of the research. What we find is that, in fact, core memory is very distinct from memory for peripheral details, and you should not rely on the peripheral details to infer anything about the reliability of the core memory. So that's another common misconception. The notion that false memories are proliferate is very common in the area of child sexual abuse. In fact, the rates of false reports based on false memories are exceedingly low. Some estimates are that it's less than 0.5%, slightly higher estimates about 2%, and that it doesn't get much bigger than that. So it's not a major concern in the area of child sexual abuse. The notion that memory is continuous, like a videotape, is very common, and it leads to the idea that in intensive questioning in an investigation or in court, you know, if you just keep questioning, you'll get people to kind of replay it, and you'll keep getting, you know, the same reports about footage from part A or part B or part C of a kind of an analog tape of memory. But that's not how memory works at all. We don't have continuous memories. The way our memory systems operate is really, you know, our eyes shift around, they do saccadic shifts, they grab little snippets of information perceptually, then some of that fades even before we have a chance to make sense of it cognitively, and so the loss continues. We interpret it based on our own worldview, based on our own experience, based on our own understanding. So there's nothing camera-like or videotape-like about what we're doing when we encode memories. And, you know, after we've made sense of them in whatever way we can, we still have to transfer them into our long-term memories, our storage, and then we have to retrieve them again. And all of those processes are such that errors occur along the way, and there are difficulties at different stages. And so we tend to have, at the most, fragments of experiences, nothing like a video recorder. There's a very common notion that if you have a traumatic event in your life, that it will be vividly imprinted on your brain, and you will hear phrases like that in many common language and discussion about something being etched in your memory permanently. But what we know from studies now is that vividness is totally separate from accuracy. so you can have a very intensive, vivid recollection, but that has no bearing on the accuracy. And emotion affects people in different ways, and so it might depending on how you respond to trauma and your coping style, the impact on your memory is differentiated. So it would be wrong to think that just because something is a traumatic memory, you have an enhanced recollection. That's not going to be true for probably at least half the people. And for some of them, their memories of traumatic events are going to be so fragmented because they have coping styles and consequences of the trauma that impair and their capacity. So that's not borne out. The notion, I think we've already discussed, repression problems. The idea that children are extremely suggestible has been refuted by some contemporary research in particular. I really think in the past, since 2008 especially, there have been numerous publications highlighting the strength of children's memory at different ages and showing that they are in many instances more resistant than adolescents and adults to suggestion, because they are relying much more on what we call their episodic or their event memory when they recall things, whereas adults and adolescents have more sophisticated understanding of the world and have a better development of categorization and classification of what we call conceptual memory. And when you rely on your conceptual memory, you distinguish it from your episodic or event memory, and then you tend to fill in the gaps based on your predictions about things, based on your understanding of the categories and classifications. And so children are more faithful and reliable when they haven't yet developed those categories and classifications that adolescents and adults tend to rely on, that make them more error-prone. And then the notion that memory, just fades steadily over time. And I think that's very commonly stated in legal texts and judicial opinions. But in fact, the forgetting rates don't work steadily over time. They operate differently. And so I'll come to a few more slides that unpack that in more detail. So I want to just highlight some of the general memory operations, and there's a lot of detail on these slides that you'll have to go through later, but I wanted to make them fairly comprehensive so that you had a sort of a mini summary of the full report to work from. I've made the main point that our memories are not replicas of experience. Memory is very dynamic. It changes. It's reconstructive based on our personal understanding and viewpoint. So what's different about some of the research that is focused on events, that it doesn't really take autobiographical meaning and memory into account, whereas child sexual abuse is a very prominent autobiographical event in people's lives, and so all of the work on meaning and autobiographical memory has more salience in this arena. The idea that we should accept that we make errors and that we make contradictions in our memories becomes more palatable if you understand how memory works, that at different times you retrieve things differently in response to different cues, and in response to questions from different people. It triggers different things in your memory, and so your reports of the same event might be very different depending on who you're talking to, based on your interpretation of what they can understand and what they're interested in. And so that reconstruction gets shaped by the social context and may include errors especially as we age and we have that conceptual classification that starts to interact with the episodic memory. We're very poor at constructing time frames retrospectively. We make enormous, misestimations in that regard. But the major processes to differentiate are what happens at encoding, what happens, so that's the acquisition process that I was describing just now, what happens during the storage or retention, or the consolidation process when those memory traces of events are transferred into our long-term memory, and then what happens when we try to bring memories back into consciousness through retrieval and recall cues. And different impacts of each of those processes affect the accuracy and completeness of how we report. So things that are very critical to know about encoding is that if you don't attend to it, it's never going to get into memory. So it has to be consciously processed, and there are gaps all the way along. And then a second very important event distinction with childhood sexual abuse is that not all abuse is experienced as traumatic by children at the time. Very often that's adults projecting onto children what they think the event ought to have been. But skilled child sex offenders usually employ grooming techniques. They're usually individuals who are very well known to the children, so children are not fearful or traumatized in their company. And usually there's a very methodical, slow acclimatization process, so the children get slowly used to being touched in perhaps slightly more intimate and personal ways, intrusively, over a long period of time, or are told this is fun, or it's presented in a context of this is what people do when they love each other, etc. So there's a complete obfuscation and a kind of a distortion of the event that is very deliberate on the behalf of the offender. And so it's very awkward for children to code that as a trauma, because there's nothing scary or dangerous necessarily at the time, because violence is quite rare in cases of child sexual abuse. So the primary perpetrators are not the stranger danger kind of event. It's usually well-known, trusted friends, family members, siblings, etc., who are the perpetrators. So there may be a long time that passes before children mature and have a different understanding based on their maturation and greater social knowledge about what actually occurred. And so it can take a long time before they report for that reason. But if memory of an event is traumatic at the time, that is very likely to lead to more sparse encoding, more fragmentary memories rather than complete memories. So again, that goes counter to what many people believe. The consolidation, or the next major phase of memory, is important to understand, because for something that is a memory trace from your encoding, and it's good to think of it in a sense of an evidentiary trace, like forensic evidence, for that to be transferred into a consolidated memory takes work and effort. So usually it takes rehearsal or repetition or some exertion of effort on behalf of the individual before it becomes a long-term trace that you can retrieve. So when I was a young student at university in my first year and knew very little about memory processes, I sat in my lectures and thought, I'll just write down what I really don't know, because it all seems so obvious, especially if you're studying psychology. And at the end of the year, I had exceedingly few notes, it turned out. And I rapidly learned how quickly things, got lost out of your short-term memory store, and how hard it was, in fact, if you hadn't done something deliberate to make them retrievable or transfer into your consolidated memory. There was no chance at all. So I became very good at verbatim writing after a few nasty experiences as a result of my naivete about the model of memory at that point. This consolidation point is also important in terms of the forgetting rates, Because what happens when you've just gone through an experience within the next day or so, you still can access quite a lot of the details from the episodic memory of that event. And then, depending on the nature of the event, it starts to fade. But usually your episodic detail memory fades within, 2 to maybe 30 days. So depending on the kind of event. If it's an event that is common and repeated, you're just not going to encode all of those details anyway, unless it's salient and significant to you for some reason. So personally significant things that stand out might be treated differently from others that seem more routine. So there's a very rapid drop-off, and if you want to see the shape of the curve, look for Ebbinghouse's work, but the deceleration is really exponential in terms of loss of detail, and then it's stable and doesn't continue to decline dramatically. Then it stabilizes, and so over years it's probably going to be much the same. So that's an important feature of how memory functions in a day-to-day fashion. What we tend to recall are the core central events and not the minor surrounding events, such as you might remember, obviously, the nature of abusive acts and who the perpetrator is, but you're less likely to be able to recall the time that a certain event occurred, the clothing that someone was wearing, and what words precisely were uttered. So those would be sort of more peripheral to the core event, and so it's very typical to lose those. All right, if you're looking at consolidation of traumatic memories or repeated events, there are a couple of things that are important to note there. When we do things over and over again, like eat breakfast or go to restaurants, and it's a common kind of experience in our lives, because we're cognitive misers, we tend to do things to minimize the amount of effort that we have to exert over those. So we develop a template or a schema for common kinds of experiences. So you know that if you're going to go to the movies, there's a predictable sort of set of events and the way that it unfolds. Or if you go to a restaurant, someone will come with a menu and you'll order, and later on, you'll pay and leave. And you don't encode all of the details once you have a good template because it's predictable. And so, you're unconsciously trying to lessen the load that has to be transferred into your long-term memory store by relying on the template. So if child sexual abuse is repeated over and over and over again, as is very typical, then the victims develop a template for that event. And so they're going to be very incapable of answering questions about, on the fourth time, that the perpetrator did X to you, was he wearing, this color clothing or that color clothing, or were you, in place A or place B? That kind of information will be subsumed into the template. And so that's why those requests for particularization in persistent types of child sexual abuse are so impossible for the victims to retrieve and supply. But they can reliably report the core events. But the kinds of errors that they would make would be what we would call transposition or intrusion errors, where something that happened on occasion 6 might be muddled in their minds with something that happened on occasion 4 because of the non-specificity of the coding once a template is developed. So now on a little bit to the retrieval issues, and I think the most important things to know about retrieval are that it's very sensitive to precisely the cues at a particular time, and that once you've started to retrieve information, you often go on later on retrieving further details about an event, so that if you have a legal practice where you're asked to retrieve everything now, can you remember anything else about this event, and the witness says, no, I can't, and then the next day or in the next week, the witness spontaneously remembers additional details, the law tends to regard those subsequent reminiscences in a very negative light. Those are regarded most typically as fabrications or as unreliable by the legal profession. But when researchers have compared the quality of those reminiscences subsequent to questioning, they have found that they're generally reliable. And so we have a problem with the type of legal practice and doctrine on that issue and with normal memory functioning. And so we might need to adjust the kinds of procedures that we follow to take this sort of spontaneous retrieval or recollection into account. There are a host of other specific features that I've listed in the next series of slides, but I won't have time to work through in depth with you today. So I'll jump to, I think, a little bit just specific to young children, because there's so much question about whether or not they're reliable. And the major take-home point about young children's memories or about other vulnerable victims, such as intellectually disabled or impaired victims, is that their memory processes work exactly the same way as do those of adolescents and adults. So there's nothing different except the quantity or the speed with which they can work. So very young children might encode less than adults in the same circumstance. They might forget faster, but their core recollection and their core memory processes for those events will be reliable. So if you have the perception that children are, willy-nilly unreliable and completely suggestible, it's not borne out by rigorous research on this topic. They are delayed in developing the capacity to answer questions about time that most adults use, because children tend to code things by context rather than linear calendars or days of the week or months or seasons that adults might use. And so a lot of things go wrong in terms of questioning children using those kinds of cues. If you say to them, did this event happen in January, it's not going to be very meaningful to a young child who hasn't yet learned the calendar and the sequencing, and that develops mostly in about the middle school age years. And if you say to people, do you remember an event that happened around Christmas? What we've learned is that children tend to take those kinds of seasonal cyclical events, if they're festivals or whatever, and they think that you mean the next one coming up. And so they just get baffled by that kind of question because they don't interpret it retrospectively. So that's not an effective questioning technique to try to get children to distinguish a particular event from another with that sort of adult labeling system. If somebody reports that they recollect abuse and they're an adult and they're retrospectively saying that they recall events, in early childhood years when they were 2, 3, 4, 5, etc., that kind of report should be scrutinized very, very carefully, because by and large, we can't remember early childhood events. Once we mature, we are all prone to what is called childhood amnesia, and the childhood amnesic period, which is mostly inaccessible to adults' memories, is somewhere around 5 to 7 years and below. And so that's usually fairly blanked out. And if you do think that you have memories from that period, you've probably learned about events by studying family photographs or, engaged in some kind of other social activity that has taught you about them rather than retrieved them from your own memory. So that's a big cue that there might be a false report because that would be highly unusual. All right, I want to jump to some of the ending slides. I've covered that point, and I think I've talked quite a bit about the fragmentary nature. I did want to just highlight what we mean by an avoidant coping style. So if an individual experiences a trauma and at the time of the event they are so traumatized that they try to disengage from the experience or disassociate from it. They're using what we call an avoidant coping style. And if you use such a style, you actually impair your encoding by that dissociation. You know, and sometimes the dissociation can be quite extreme. People can sort of imagine themselves floating above their bodies, or, you know, in the top of the room, if they're able to dissociate to that extent. But oftentimes it's simply refusal or avoidance of confronting what is an emotionally unpleasant experience or memory. So the avoidance can be at the time as well as subsequent to the time. And that leads to much more memory fragmentation, certainly doesn't improve or enhance your recall for that event. And similarly, if you have distress at the time of retrieval, which is, as you know, quite common in the legal system, that can be accompanied by a host of debilitating processes. So, you know, it can impair, we say retrieval or reporting, because many times the victims are aware of and can retrieve, but what is impaired is their ability to articulate and narrate because of their distress. So there is a distinction between production of something into memory and, you know, translation of that into an articulated verbal report in response to an interviewer's questions. If you have in place a lot of supportive interviewing techniques, supportive personnel, including perhaps intermediaries, those kinds of interventions can assist otherwise stressed or distressed victims in doing a better job of reporting at the retrieval stage. And as I suggested, also giving people perhaps shorter interviews, multiple interviews, not repeating the same ground, but building on what was said, breaking it up into smaller sessions can also help to relieve the stress, because then what's going on gets more predictable for the victim. All right, so just to wrap up, I'm going to see if I can get back. I don't know if I can. You know, what I don't know if I can do this at all. Let's see if I can. This doesn't work exactly the same way as the computer. Sorry, I jumped somehow out of the rest of these. So if I can just get to the slide where I want to wrap up. It'll be here. What our Royal Commission has done with all of these findings, I think I'll just use them too, like this. Okay, thanks. I think we're right at the end. You know, try to distill what might be considered some best practices that people can use to incorporate these findings. And the golden key is to use open-ended questions that are free recall prompts, so that there's an opportunity to get a narrative from a witness. And of course that flies in the face of cross-examination strategies and techniques. So what happens when you do use cross-examination style questions is that often they're suggestive, they're option-posing and confusing, and you tend to get a higher rate of false or unreliable information from vulnerable witnesses. The inaccuracy rate can go up because many times lawyers will repeat a question in a slightly different way to a child, and the child, you know, infers that they must have said something wrong the first time, so they change their answer to try to figure out what's going on socially. Why are they being asked the question again? And that produces, you know, inadvertent inconsistencies that are really the result of the questioning and have nothing to do with memory whatsoever. Impaired recall, you know, is especially likely when you're dealing with very young children, primary school children, and distressed witnesses who do not have support in the questioning process. So the general thrust of this work has been to try to combine memory-informed practice along with a host of typical alternate measures or special measures for vulnerable witnesses in child sexual abuse cases, whether they're adults reporting historical claims or children. And those that have been trialed in Australia now for a number of years include reliance, first of all, on a pre-recorded police interview that then becomes the evidence in chief, so the child or the victim doesn't have to be questioned once during the investigation stage and then again at trial. And the idea is that if you can just do all of the questioning once, you can then free the victim, make it a much more victim-friendly system, and allow the victim to get counseling, get treatment, and recover without recalling them repeatedly into the legal arena to repeat their stories and undergo what is stressful. So that's very commonly done, but then the child has to appear either at a special hearing for cross-examination or at trial for cross-examination. And to try to mitigate the stress, what is done in our courts is that the children are allowed to testify via CCTV or with a screen separating them from the view of the offender. And there's, this is routinely done in most states. What there seems to be a shift to try to do now is more of the special hearings where everything is done in advance. So as early as possible on the judge's calendar, after a case proceeds to trial, they order a special hearing. All the lawyers have to front up and do all of the examination, and it's all recorded. And so they do, the examination in chief and the cross-examination and redirect, and along with viewing any pre-recorded police videotape that there might be. And then those recordings are played in court or used by the trier of fact to render their decisions. In addition, to try to reduce some of the stress, witness support professionals work in all of our courts. They come from a variety of backgrounds. They've been deemed necessary because many times in child sexual abuse cases the families are fraught. Sometimes the non-offending parent is not sympathetic to the child, but has loyalties to the offender. And so relying on family members to provide the support has been found to be a difficult situation for many of the children and inadequate, and so a range of professionals step in to do that. And then most recently we have begun to trial the use of intermediaries, really to deal with the form of the question problem. So intermediaries who are really skilled in linguistics primarily are there as neutral parties to intermediate when the form of the questions that are posed to the children are outside of the range of their age development, or are confusing or compound, unduly cross-examination style rather than open-ended narratives, to try to shift the legal culture away from imposing that cross-examination style. So that's where we are at this point, and I'm apologizing if I've run a little longer. I seem to have. I will take questions.
Ma'am, can you just categorize at what age the child loses its memory after an abuse? For suppose an example, a child who have undergone an abuse at the age of 3 years, and in our Indian context the trial comes after 1 year, after 1 year. So it is very hard to make the child to retrieve the incident. So can you categorize at what age the child forgets whole of the incident and come back to a normal condition?
I mean, as I've indicated, there's more rapid forgetting that might happen with children, but they probably are going to be able to retain memory of those core events just as adults would. And part of the difficulty with a 3-year-old might be the extent to which they are still pre-verbal or verbal, and so you need to have specialized questioning techniques to try to remember, to try to trigger the cues that were used to encode the experience. And if it's a pre-verbal child, they're going to remember not in language. So if you're relying on language, you might run into a roadblock in terms of getting responses. But if you can get the child to use actions or are skilled in decoding what the child is reporting, you might be able to interpret it from an adult perspective. So one example narrated by one of the clinicians at our round table was about a young child who reported being subjected to pressure and had, and it was quite some time. She told other people very soon after the event about feeling this pressure on her, and nobody understood what she was referring to. It was quite some time later that people realized she was talking about the weight of what she experienced physically when somebody had rested on her during an abusive episode. So I think the answer is not that they're not going to be able to retrieve it, but their understanding might change, and certainly sometimes you need people who are skilled at that age of development really to be able to use nonverbal cues, and that doesn't mean using dolls to get people to try to enact it, because people have found that when you tried techniques with dolls, the children were more distracted by the dolls and produced information with the dolls that wasn't reliable. So those have generally fallen into an area of, reserved for concern, should not be used to produce reliable memory reports. So I'm talking about other kinds of nonverbal conveyance of information, maybe through gesture, whatever a 3-year-old might use. Some very young children really do rely on, much more akin to sign language, and you need someone who can decode it. Many people these days are teaching their children who are pre-verbal how to use sign language, and you'd be amazed how fast they are at communicating what they think and feel. I've seen 1-year-old children, doing fantastic communication when they know what the cues are to give, and they have no idea about the language that goes along with it. Yes? Memory of a? I don't know. We didn't uncover any research about reliability of dreams. So I really would have to say I'm not able to comment on that from an empirical standpoint.
I believe there have been studies that show that memory is lost to amnesia are not in fact lost, but are simply inaccessible. So they are in fact intact and potentially retrievable. So what kind of techniques would be employed to help people retrieve memories from, let's say, of abuse below 10 years of age, and how would the law view this kind of evidence?
Okay, so I mean the standard recommended questioning techniques, are to try to use open-ended questions and encourage people to produce a narrative. If somebody has amnesia, that's often generated by shock, and it can be prospective or retrospective, for periods of maybe a week or a month. If you're in profound shock, those memories that are subject to amnesia may not be retrievable or encoded. So I don't know that I would adopt a stance saying that if someone has amnesia, you simply have to go on, trying to get them to remember. If people are not responding to open-ended kinds of prompts or questions, that may be as far as you can go. But after some time, people who have experienced amnesia often experience some kind of remission of the amnesia. You may simply have to wait. In other words, ordinary forgetting might be different than a period of stress-induced or traumatic-induced amnesia. I think that you can have full amnesia for a time and then slowly start to recover memory maybe a month or two later. So it seems to me that there's probably going to be more stress imposed if you pressure someone to try to remember something that they can't. I don't know if that's responsive to what you're asking.
That does, thank you. But I was referring to cases of memories lost during childhood amnesia, as you mentioned in your...
I'm not sure I'm understanding. Memory loss, that is...
during childhood amnesia, you mentioned that children during the age of, below the age of 5 or 7 years would be less susceptible to remembering their...
I think maybe you're misunderstanding what I said. What I said is adults have no memory of the events below that age. So adults have what is called childhood amnesia, and no, you can't get people to retrieve that reliably. Children who might be 3 or 4 or 5 will have memories of recent periods, but when they reach adulthood, those memories will no longer be recoverable or retrievable by them. So if you are dealing with a young child, they're not subject to the phenomenon of adult childhood amnesia yet. They still have the capacity to recall things that might have happened, 1 or 2 years before during their earlier childhood. Is that more helpful?
Yeah, thank you.
When you say that the play therapy, especially playing with the dolls and then the child happening to what has happened with the child, if that is not reliable, like using of dolls or playing with clay or something what the child likes to, if that is not reliable, then object relation therapy or which says that mother is good enough, the child reveals more in with the mother, whatever what the child undergoes. In that case, can the mother's version will be reliable, taken into consideration as an evidence? What happens?
No, I think there's a very important process of memory consolidation that happens between young children and their mothers or their primary caregiver. So, the way that we learn to store memories oftentimes is with a caring parent who talks to us about the events that happened during the day to us and how we felt about them. And we're going through a process of rehearsal and recounting and narrating. And so that is often called in the literature maternal reminiscence, actually. And it is and when children have mothers who engage in that kind of process with them, not to distort their memories, but generally, out of interest in their children's development, that's very key. And those children tend to have much, much better memories in the first place than other children of the same age whose mothers don't engage in that sort of discussion or reminiscence with them. So it's a very important memory development and consolidation process. So I don't want to in any way denigrate that process because of its importance in all of the literature. I think if children are disclosing episodes of abuse that they've experienced, who are they going to disclose it to in the first instance? You have to be concerned about. They're going to, younger children are perhaps more likely to report it to someone that they trust, like a mother, if the mother is not an abuser. than perhaps because they don't have a bigger social circle of friends. And so who people report to can itself become an issue of evidence, and then there are a whole lot of evidentiary doctrines that would be investigated to consider whether you will take, you know, some sort of hearsay statement into account or not if the mother is reporting what the child said. Even if that's barred from trial, that might be the basis for someone else to do a later interview and investigation with the child. You know, so the child's not going to know. I have to report what happened to the police. They're not going to even know, you know, who the police are. So if there's a disclosure, people to whom disclosures are made, if they're well informed, might notify the authorities. So it's very likely to be a parent.
So it depends on case to case?
I think it depends on the context as to how that information might be construed.
In that case,
you know, I mean, if you look at what goes on in many disputed custody cases, you know, acrimonious divorces lead to lots of parents making allegations that the other parent is abusing the child. You know, if you're in that kind of context, you've got to, you know, consider the motivations of the adults and the report that you're receiving differently than if you were not in that kind of context.
We kind of gone over time, so thank you so much, Jane. So now let's put our hands together for a...
Thank you for listening.
And I'm going to do the more... Avanindra, Monica, Karan, Akshita Pandit, Pradyuman,